Bismillahirrahmanirrahim. The topic of this video is procedure for winding up dissolution of companies. Viewers, the term winding up of a company may be defined as the proceedings by which a company is dissolved. That is, the life of a company is put to an end. Thus, the winding up is the process of putting an end to the life of the company, and during this process, the assets of the company are disposed of, the debts of the company are paid off out of the realized assets or from the contributories, and if any surplus is left, it is distributed among the members in proportion to their shareholding in the company. The winding up of the company is also called the liquidation of the company. The process of winding up begins after the court passes the order for winding up or a resolution is passed for voluntary winding up. The company is dissolved after completion of the winding up proceedings. On the dissolution, the company ceases to exist. So the legal procedure by which the existence of an incorporated company is brought to an end is known as winding up, or we can say dissolution of company. So viewers, the step number 1, liquidator. A person appointed to carry out the winding up of a company is called liquidator. If the winding up is through court, the term used for such person is official liquidator. The duties of liquidator include to get in and realize the property of the company, to pay its debts, and to distribute the surplus, if any, among the members, that is, shareholders. The official liquidator acts under the supervision of the court through a recognized reporting system. The following are the general powers of liquidator: to constitute or defend any suit, action, prosecution, or other legal proceeding, civil or criminal, on behalf of the company. Second one is to carry on the business of the company so far as may be necessary for the beneficial to it. The third one is to pay to the creditors. Number 4, to make any compromise or arrangement with creditors. Number 5, to compromise all calls and liabilities to calls, debts and liabilities capable of resulting in debts. Number 6 is to sell the movable and immovable property and things in action of the company by public auction or private contract with power to transfer to any person or to sell the same in parcels. Number 7, to do all acts and to execute all deeds, receipts, and other documents in the name and on behalf of the company, and for that purpose to use in the company's seal when necessary. Number 8 is to prove rank and claim in the bankruptcy, insolvency, or sequestration of any contributory for any balance against his estate, and to receive dividends as a separate debt due from the bankrupt or insolvent in the bankruptcy. Number 9 is to draw, accept, make, and endorse any bill of exchange or promissory note in the name and on behalf of the company. Number 10 is to raise on the security of the assets of the company any money. Viewers, number 2 is consequences of winding up. Some important consequences of winding up of company are: as regards the company itself, winding up does not mean that the company has ceased to exist. The company exists as a corporate entity with all the rights of such entity, with only change that its management and administration is to be carried on through liquidator, and the liquidators till the final dissolution of the company. As regards the shareholders, a new statutory liability as contributors comes into existence. Every transfer of shares or alteration in the status of a shareholder after the winding up has commenced by the order of the court shall, unless approved by the liquidator, be void. As regards the creditors, they cannot file or continue suits against the company except with the leave of the court. They cannot proceed with the execution if they have obtained degrees already. They must lodge their claim and prove their debt before the liquidator. As regards the management, on appointment of liquidator, all the powers of the directors, chief executive, and other officers shall cease except for the purpose of giving notice of resolution to wind up and appointment of liquidator and filing of consent of liquidator, etc. As regards the disposition of company's property, all such dispositions are void unless with the leave of the court or the liquidator. Viewers, third one is modes of winding up. The winding up of a company may be either as under the law, number one is by the court, or voluntary, or subject to the supervision of the court. Now we have discussed the first one, winding up of the company by the court. The winding up of a company by an order of the court is called the compulsory winding up. Section 305 of the ordinance investigates the following circumstances under which a company may be wound up by the court on the petition submitted to it. If the company has by special resolution resolved that the company be wound up by the court, if default is made in delivering the statutory report to the registrar or in holding the statutory meeting or any two consecutive annual general meetings, if the company does not commence its business within a year from its incorporation or suspends its business for a whole year, if the number of members is reduced in the case of private company below 2 or below 3 in case of a public company and below 7 in case of listed company, if the company is unable to pay its debts, if the company is conceived or brought forth for or has been carrying on unlawful or fraudulent activities, carrying on business not authorized by the memorandum, conducting its business in a manner oppressive or to any of its members or persons concerned with the formation or promotion of the company or the minority shareholders, run and managed by persons who fail to maintain proper and true accounts or commit fraud, misfeasance or malfeasance in relation to the company, or managed by persons who refuse to act according to the requirements of the memorandum or articles or the provisions of this ordinance, or fail to carry out the directions or decisions of the court or the registrar or the commission given in the exercise of powers under this ordinance. If being a listed company, it ceases to be such company, if the court is of opinion that it is just and equitable that the company should be wound up, number one, complete deadlock in the management of the company, failure of company's main object, recurring losses, aggressive or oppressive policy of majority shareholders, incorporation of company for fraudulent or illegal purpose, and last one is public interest. Viewers, if the company ceases to have a member, the next one is procedure for winding up of company and filing of petition before respective High Court. To pass special resolution by 3/4 majority of the members of the company that the company be wound up by the court in case if the company itself intend to file a petition and to file the special resolution on Form 26 with the registrar. To prepare a list of the assets to ascertain that the company is unable to pay its debts. To prepare a list of the creditors. In case of defaults in payments, the creditor or creditors to make a decision for the filing of the winding up petition. In case if the commission or registrar or a person authorized by the commission intend to file a petition, they should not file a petition for winding up of the company unless an investigation into the affairs of the company has revealed that it was formed for any fraudulent or unlawful purpose, or that it is carrying on a business not authorized by its memorandum, or that its business is being conducted in a manner oppressive to any of its management, has been guilty of fraud, misfeasance or other misconduct towards the company or towards any of its members. To engage advocates for the preparation and filing of the petition. Viewers, next one is who is competent to file petition for winding up in the court. A very important one is petition may be presented by any one of the following. The company may itself by passing a special resolution, creditor or creditors, any contributory or contributories, registrar of companies, Securities and Exchange Commission of Pakistan, or by a person authorized by the commission. Now the next step is checking list filing of petition before respective High Court. Number one is, have you gone through general heading provided under rules, that is rule 4 of the rules. Number 2, whether the petition is prepared, drafted on and in accordance with the rules, that is rule 75 of the rules. Number 3, have the petition's written statements, affidavits and other proceedings are being presented to the court is fairly and legally right written, typewritten, cyclostyled, etc. and in accordance with the format described under the rules, that is rule 5 of the rules. Number 4, have the language of the said document stated at column 3 are in language of the court, that is rule 6 of the rules. Now, what are the documents to be annexed with the petition? Number 1, petition for winding up to be filed on form prescribed under the company's rule on Form 24, which is general form, Form 25, petition by creditor, Form 26, petition by company. This is Rule 75 read with Rule 4 of the rules. Number 2 is affidavit verifying the petition on Form 1. This is Rule 16 read with Rule 4 of the rules. Number 3, copy of special resolution in case if the company itself intend to file petition, that is under section 172 of the ordinance. Number 4, copies of the agreements and other documents on the basis of which creditors intend to file a winding up petition will be annexed with the petition. Number 5, all other supporting documents on the basis of which the petitioner rely as an evidence. Viewers, now voluntary winding up of members of the company. A company can be wound up voluntarily on expiration of the period fixed for the duration of the company by its articles of association or on occurrence of event leading to dissolution of the company as provided in the memorandum and articles of association, and company has to pass a special resolution in general meeting for its wound up voluntarily within 5 weeks of filing of declaration of solvency, and on passing of the special resolution that the company be wound up voluntarily. A voluntary winding up is deemed to commence at the time of passing of the resolution for voluntary winding up. The company ceases to carry out business just on commencement of winding up. However, it can carry on its activities and business for beneficial winding up of the company. Now viewers, procedure for voluntary winding up. Viewers, the following steps are to be taken for members voluntary winding up under the provisions of the ordinance and the company rules. Step 1. Where it is proposed to wind up a company voluntarily, its directors make a declaration of solvency on Form 107 prescribed under Rule 269 of the rules, duly supported by an auditor's report, and make a decision in their meeting that the proposal to this effect may be submitted to the shareholders. They then call a general meeting, annual or extraordinary, of the members under section 362 of the ordinance. Step 2. The company, on the recommendations of directors, decides that the company be wound up voluntarily and passes a special resolution in general meeting, which is annual or extraordinary, appoints a liquidator and fixes his remuneration. On the appointment of liquidator, the board of directors ceases to exist under section 358 and 364 of the ordinance. Step 3 is notice of resolution shall be notified in official gazette within 10 days and also published in the newspapers simultaneously. A copy of it is to be filed with registrar also under section 361 of the ordinance. Step 4 is notice of appointment or change of liquidator is to be given to registrar by the company along with his consent within 10 days of the event under section 366 of the ordinance. Step 5 is every liquidator shall within 14 days of his appointment publish in the official gazette and deliver to the registrar for registration a notice of his appointment under section 389 of the ordinance on Form 110 prescribed under rules 271 of the rules. Step 6 is if liquidator feels that full claims of the creditors cannot be met, he must call a meeting of creditors and place before them a statement of assets and liabilities under section 368 of the ordinance. A return of convening the creditors meeting together with the notice of meeting etc. shall be filed by the liquidator with the registrar within 10 days of the date of meeting under section 368 of the ordinance. Step 8 is if the winding up continues beyond 1 year, The liquidator should summon a general meeting at the end of each year and make an application to the court seeking extension of time under section 387 subsection 5 of the ordinance. Step 9 is a return of convening of each general meeting together with a copy of the notice, accounts, statement and minutes of the meeting should be filed with the registrar within 10 days of the date of meeting under section 369 of the ordinance. Step 10. As soon as affairs of the company are fully wound up, the liquidator shall make a report and account of winding up, call a final meeting of members, notice of convening of final meeting on form 111 prescribed under rule 279 of the rules, before which the report accounts shall be placed under section 370 of the ordinance. Step 11. A notice of such meeting shall be published in the Gazette and newspapers at least 10 days before the date of meeting under section 370 of the ordinance. Step 12. Within a week after the meeting, the liquidator shall send to the registrar a copy of the report and accounts on form 112 prescribed under rules 279 of the rules. Viewers, documents required for voluntarily winding up by members. Special resolution on form 26 prescribed under the company's general provision and forms rules 1985 for voluntary winding up. Declaration of solvency on form 107 under the rules. Affidavit by directors of the company, including chief executive, verifying the attached auditor's report, profit and loss account, balance sheet, statement of assets and liabilities, prepared from the date of closing of last accounts till the latest practicable date immediately before the making of declaration. Consent of liquidator. A copy of notice of resolution passed for winding up the company voluntarily and published in the official gazette. A copy of notice for appointment of liquidator and published in the official gazette. A copy of preliminary report prepared by the liquidator. Final report and accounts of the company prepared by liquidator, presented in general meeting of shareholders after finalization of winding up. Notice of final meeting. Return containing final report and accounts along with minutes of meeting to be filed with the concerned company registration office. Creditors voluntary winding up of the company. A procedure has been laid down under the provisions of the ordinance whereby company can also be voluntarily wound up by creditors. For this purpose, the company shall call a meeting of the creditors of the company to be summoned for the day or the day next following the day on which there is to be held a general meeting of the company at which the resolution of voluntary winding up to be proposed. Now, the procedure for creditors. Step 1 is first of all, the company passes a special resolution in the general meeting of the members of the company, for which following steps are to be taken. Board of Directors approves the agenda of the general meeting, especially the draft special resolution for winding up of the company. Notice of the general meeting along with company of the draft special resolution is given to the members at least 21 days before the general meeting. Special resolution is passed by 3/4 majority of the members of the company, and the members appoint a person to be liquidator of the company. Special resolution on form 26 is filed with the registrar. Step 2. Meeting of meeting of creditors is called at 21 days notice simultaneously with sending of the notices of the general meeting of the company. The notice of the meeting of the creditors to be sent by post to the creditors, besides the notice of the said meeting to be advertised in the official gazette and the newspaper circulated in the province, and the creditors pass a resolution of voluntary winding up of the company. The creditors also appoint liquidator in that meeting. If the creditors and the company nominate different persons, then person nominated by the creditors shall be liquidator. Step 3. Notice of the resolution passed at the creditors meeting shall be given by the company to the registrar along with consent of the liquidator within 10 days of the passing of the resolution. The company may either at the meeting at which resolution for voluntary winding up is passed or at any subsequent meeting may, if they think fit, appoint a committee of inspection consisting of not more than 5 persons, provided that the creditors may, if they think fit, resolve that all or any of the persons so appointed by the company ought not to be members of the committee of inspection. Step 4 is the liquidator should with all convenient speed realize the assets, prepare list of creditors, admit proof, settle list of contributories, make such calls as may be necessary, etc. Accordingly as the nature of the case may require, pay secured creditors, pay the costs including the liquidator's own remuneration, pay preferential claims, and after meeting all the claims of creditors and after adjusting all claims and rights, distribute the surplus on pro rata basis. Step 5 is in the event of the winding up continuing for more than 1 year, the liquidator shall summon a general meeting of the company and a meeting of creditors at the end of the first year from the commencement of the winding up, and lay before the meetings an audited accounts of receipts and payments and acts and dealings and of the conduct of winding up during the preceding year, together with the statement in the prescribed form and containing the prescribed particulars with respect to the proceedings and position of liquidation, and forward by post to every creditor and contributory a copy of the account and statement together with the auditor's report and notice of the meeting at least 10 days before the meeting required to be held. Step 6. The liquidator prepares the accounts, gets them audited, and also presents a final report to the creditors. The steps at this stage are as under. The liquidator prepares a final report and accounts of the winding up, showing how the winding up has been conducted and the property of the company have been disposed of. Accounts are duly audited by the auditor appointed for the purpose. The notice of meeting is sent by post to each contributory of the company and creditor at least 10 days before the meeting. The account with a copy of the auditor's report is also enclosed with the notice. The notice of the meeting specifying the time, place and object of the meeting is published at least 10 days before the date of meeting in the official gazette and in at least one newspaper. Within 1 week after the meeting, the liquidator is required to send to the registrar a copy of his report and account and make a return to him of the holding of the meeting along with the minutes of the meeting. If a quorum is not present at the meeting, the liquidator makes a return stating that the meeting was duly summoned and that no quorum was present thereat. The return is filed with the registrar and considered as presented in the meeting. The registrar, on receiving the report, account and the return, is required to register them after their scrutiny. On the expiration of 3 months from the registration of final report, accounts and minutes, the company is deemed to be dissolved. Viewers, next is winding up of the company subject to the supervision of the court. When a company has passed a resolution for voluntary winding up, the court may, of its own motion or on the application of any person entitled to apply to the court for winding up a company, make an order that the voluntary winding up shall continue, but subject to such supervision of the court and with such liberty for creditors, contributories, and or others to apply to the court, and generally on such terms and conditions as the court thinks just. A petition for the continuance of a voluntary winding up, subject to the supervision of the court, shall, for the purpose of giving jurisdiction to the court over suits and other legal proceedings, be deemed to be a petition for winding up by the court. The court may, in deciding between a winding up by the court and a winding up subject to supervision, in the appointment of liquidator and in all others matter relating to the winding up subject to supervision, have regard to the wishes of the creditors or contributories as proved to it by any sufficient evidence, but subject to the provisions which would have been applicable had the company been wound up by the court. Viewers, this is our video for the procedure for winding up and dissolution of companies in Pakistan. For any question, please write in the comment section of this video. We will reply as early as possible. If you like our channel, kindly subscribe this